For decades, the crime of rape has been known as the easiest criminal accusation to make by the alleged victim and the hardest to disprove by the defendant. In the 1960s, the victims of this brutal crime were able to take advantage of significant changes in the law that made it easier to obtain convictions and justice. Unfortunately, these changes also made it easier for those who were falsely accused of rape to be convicted as well. Adding to the defendant's difficulty is the controversial rape trauma syndrome, a psychological theory that has been rejected by behavioral scientists. Unfortunately, this idea is still being used by prosecutors and junk science witnesses as so-called evidence in cases against the defendant accused of the crime of rape. A series of biased laws are making it easier to obtain convictions. First, jury instructions are the law that is read to the courts. Courts have known that rape is the easiest allegation to make, but one that is hard to disprove. In fact, the biggest threat of being falsely accused of a crime was that of being accused of rape, until child molestation became a significant national issue, flooding the legal system with those types of cases. It is now the most likely false allegations. Courts perceived the potential threat of false allegations of rape and fashioned jury instructions to inform members of the jury that such allegations were easy to be made but difficult to disprove. Today, in most states, this jury instruction is no longer allowed to be given as a result of changes in the law. Changes that also mandate giving a very different set of jury instructions. In many states, the judge now informs the jury that 1, an allegation of rape does not require any evidence of corroboration. 2, there is no requirement for medical evidence. 3, there is no requirement for DNA evidence. 4, there is no requirement for a second witness. In short, the only requirement for a conviction is the bare allegation made by a complainant. Even the manner in which the jury is selected is tainted with this attitude that evidence doesn't matter. In many states, prosecutors can demand that during jury selection, each prospective juror must agree that he would not require corroboration of a crime. If the juror disagrees with this demand, he or she can be excused for cause. We then have the rape shield laws. By the way, consensual sex is still legal. Being able to prove consent, however, becomes much more difficult for the defendant. For example, if a man meets a woman at a bar and has sex with her that night, and later she claims she was raped, the man used to be able to introduce evidence to help establish a pattern of consensual sex on the part of the woman. That might be the testimony by witnesses that a woman routinely came to the bar every night, engaged a man's companionship, and went home and had sexual relationships with him. Such evidence is relevant to show the sex on the night in question is consensual, but now it's not admissible. Victims' rights advocates were rightly concerned with the legal strategies that put the victim's personal life on trial. Unfortunately, highly relevant evidence that could have protected an innocent defendant is no longer allowed because politics has obscured justice and powerful lobbies have helped to pass what is now called the rape shield laws. Under those rape shield laws, a defendant in today's courtroom is forbidden from introducing the prior sexual conduct of the complainant on the issue of consent. Curiously, no one has successfully shown that the evidence of prior sexual conduct is not relevant in determining consent. While the rape shield laws were intended to encourage more women to come forward and testify, it simply has made it easier to falsely accuse and convict an innocent individual. Many states also allow the prosecution to introduce allegations made by other women allegedly assaulted on previous occasions by the defendant to prove that a rape occurred in the current charged offense. It doesn't matter even if those allegations are 30 years old. In these circumstances, no corroborating evidence is required to introduce these old allegations. There does not even have to be a conviction, nor does there even have to exist a criminal charge or even a police report. The uncorroborated word of a single individual is sufficient. As you see, many state legislators are creating new victims by keeping out the sexual history of the complainant on the issue of consent, but allowing into evidence remote sexual history or allegations of sexual history of the defendant. This is sheer politics and not based upon relevancy or fair play. This kind of legislation is systematically making it easier to obtain convictions. While those guilty of rape should be convicted, those who are falsely accused should be allowed to defend themselves adequately in court. Now, let's look at rape trauma syndrome. The members of the jury are the triers of fact. They hear the account of the complainant, and if the defendant elects to testify, they hear the testimony of the defendant. This is the classic he said, she said situation in which jury members must decide who is telling the truth. In an attempt to provide greater credibility to the complainant and thereby tip the scales of justice in favor of conviction, Ann Burgess and Lynn Holstrom wrote a psychological description of what they called the rape trauma syndrome. This was written in 1974. A true syndrome is a constellation of symptoms that, when presented by an individual, leads to a diagnosis of an illness. Rape is not an illness. Rape is not a diagnosis. First of all, the rape trauma syndrome is not really a syndrome because no diagnosis can be made from the syndrome. Secondly, there was no scientifically controlled study done by behavioral science professionals that support the theory of rape trauma syndrome. The fact is that this highly questionable theory is not recognized in DSM-4. DSM-4 is the Diagnostic and Statistical Manual of the American Psychiatric Association, and it is the current group of recognized diagnoses by behavioral science professionals. It includes all the current recognized diagnoses and recognized syndromes. Rape trauma syndrome is not in the DSM-4 because it was rejected by the behavioral science community, psychiatrists, psychologists, clinical social workers, and others. One reason rape trauma syndrome is unscientific is that Burgess and Holstrom assumed that any allegation of rape was true, and on that foundation devised an explanation for whatever the alleged victim might say or do. It seems their rape trauma explanation does not constitute a description of symptoms of an illness, but rather a way of manipulating evidence in favor of the complainant. For example, if a woman recants her story and admits that she was not raped and that she lied, the prosecution can put on a supposed rape trauma expert on the stand to testify that this behavior of recanting is consistent with being raped. The implication is that the original rape story should be believed and the admission of lying should not. This demonstrates why we refer to rape trauma syndrome as a confirmatory bias-based description. Believe the woman if she says she was raped, don't believe her if she says she was not raped. What is meant is that the syndrome demonstrates a built-in bias towards confirming that rape happened. In a process like this, all symptoms lead to the conclusion that it happens, and this is consistent with a prosecution expert using a confirmatory bias model. Our office has never witnessed a so-called rape trauma expert testify that the complainant's behavior is also consistent with false allegations of rape. This is true even though it is widely known and accepted by legitimate researchers in the behavioral sciences. Other descriptions found in the rape trauma syndrome explain that if a woman immediately reports such action, that is consistent with the typical reaction of a rape victim. Curiously, this same so-called syndrome explains that if a woman waits for years to report That is also consistent with the typical reaction of a rape victim. The rape trauma syndrome folks also explained that if a woman is flirtatious, such behavior is consistent with the typical reaction of a rape victim. But if the woman is withdrawn and not flirtatious, that too is consistent with the typical reaction of a rape victim. Should the woman cry when testifying? That's consistent with the reaction of a rape victim. But if the woman doesn't cry, that is also consistent with the typical reaction of a rape victim. The list of descriptions covers almost every conceivable human behavior that a human being might have over the course of a lifetime. As you can see, this makes any behavioral evidence support the charge of an alleged victim. Burgess and Holstrom's assumption that all allegations are true is not only unscientific, it is dangerous. Such thinking is also contrary to the U.S. constitutional principle that a person is innocent until proven guilty beyond a reasonable doubt. Rape trauma syndrome is not science, but unfortunately the courts in many states have given it legitimacy by allowing the testimony of supposed experts to be heard and by allowing the prosecution to misuse the word syndrome. Can you imagine the reaction if we went in with fake rape trauma syndrome? They would laugh. This pseudoscience makes it easier to mislead the jury in order to obtain convictions, not just of those who are guilty, but those that are falsely accused as well. Let's talk for a minute about defenses. When an individual is falsely accused of rape, the defenses fall into three basic categories. Number one, the defendant did not have sex with the complainant. This means either that the complainant was lying about having sex or the complainant has misidentified her assailant. Two, the defendant had sex with the complainant, but the sex was actually consensual. And the third defense is that the defendant had sex with the complainant and the defendant had a good faith belief that the complainant consented, whether or not there was actual consent. Because the crime of rape has become a political hot-button issue, many state legislatures have passed laws that make it more difficult for anyone falsely accused of rape to introduce evidence on any of these three defenses. Being concerned with the rights of someone falsely accused of this terrible crime doesn't make politicians popular in the polls. That is why the fate of the falsely accused rests in the trial skills of the defense team to overcome this biased system. What about sentencing? There is only one thing worse than being falsely accused of rape, and that's being falsely convicted of rape. As a convicted rapist, a person falsely convicted faces registration as a sex offender for the rest of his life. In many states, the sentencing laws have become more restrictive and severe. For example, in California, the law used to state that the defendant could be sentenced up to 8 years on one count of rape, with 2 years for each subsequent count. That law was changed to punish the convicted individual with an 8-year sentence for each count, and all counts to be served consecutively. In other words, 2 counts of rape can be punished with 16 years of imprisonment instead of 8 plus 2 years add-on for a total of 10 years. More disturbing is the prosecutor's ability to turn a single alleged rape into numerous counts because different sexual acts allegedly occurred during one encounter, which now can be filed as separate crimes. For example, the falsely convicted can be sentenced to 8 years for intercourse, 8 years for rape with a foreign object, in other words, finger insertion, 8 years for sodomy, if the jury finds the defendant guilty. If the complainant alleges that the accused stopped the rape and then a few seconds later started over, each new act becomes an additional count. Extreme sentences of over 30 years up to hundreds of years have become commonplace as a result of this charging scheme. Finally, someone convicted of this crime was once given a 50% credit, half off of his sentence, for good behavior and doing his job in prison. Many states have now reduced credits for good behavior and work time, and California now gives only 15% credit. Think about that. That's the equivalent of increasing actual sentences by 70% just by changing the method by which work time credit is calculated. Well, where does this leave us? Because of the nature of the crime and the victims who felt that they had not obtained justice, the rape complainant has an army of lobbyists pressuring different state legislatures to pass laws that favor the alleged victim at the expense of the defendant's right to defend himself. Those who are falsely accused rarely have representation when new laws are being proposed. Even if the falsely accused do have a few lay spokesmen attempting to educate their state legislator, the typical politician does not want to become involved on such an explosive issue. There are few people in office willing to risk a political career for a few people who have been falsely accused of rape. The only way to overcome judicial and legal inequity is through a thorough professional investigation and with evidence presented by a highly skilled defense team. It is a matter of educating the jurors so that they can make an informed decision about what is and what is not a true allegation of rape. Injustice. Unfortunately, these changes also made it easier for those who were falsely accused of rape to be convicted as well. Adding to the defendant's difficulty is the controversial rape trauma syndrome, a psychological theory that has been rejected by behavioral scientists. Unfortunately, this idea is still false allegations. Courts perceived the potential threat of false allegations of rape and fashioned jury instructions to inform members of the jury that such allegations were easy to be made but difficult to disprove. Today, in most states, this jury instruction is no longer allowed to be given. Known that rape is the easiest allegation to make, but one that is hard to disprove. In fact, the biggest threat of being falsely accused of a crime was that of being accused of rape, until child molestation became a significant national issue, flooding the legal system with those types of cases. It is now the most likely. For decades, the crime of rape has been known as the easiest criminal accusation to make by the alleged victim and the hardest to disprove by the defendant. In the 1960s, the victims of this brutal crime were able to take advantage of significant changes in the law that made it easier to obtain convictions, still being used by prosecutors and junk science witnesses as so-called evidence in cases against the defendant accused of the crime of rape. A series of biased laws are making it easier to obtain convictions. First, jury instructions are the law that is read to the courts. Courts